where were your children during this entire, at home alone?
No, with my parents. My parents live with me.
All right, so now I know who's raising the children.
Oh, no.
Okay. Well, I mean, you were not doing it that
It
night,
was one night.
but you, according to the police report, you all were smoking marijuana in the vehicle
I'm allergic
because the
to
car smelled like, oh, you're allergic to marijuana, but y'all driving around with marijuana in the vehicle and the smell of marijuana. I find that very odd. I have some more luggage to unpack with her, but before I unpack that luggage, I want you to speak with probation, and then you're immediately going over to felony drug court.
Okay.
And probation, put her on the UA hotline, dressing appropriately for court. I really appreciate that. Now it says preparing your session. Okay. I'll see if I can find this case.
Better that than the other way, I guess.
Oh, gosh, yeah. Oh, we are finally where I need to be.
Yeah, that's funny. That's awesome.
So how was your trip?
Oh, it was outstanding. I'll have to show you some of the pictures and photos later. The weather cooperated thing.
Oh, that is
It's
awesome.
Super hot.
All right, so on this case, where are we on discovery? And I know because of the sensitive matter, it's not going to be available by normal means. So,
Correct. Judge, I believe all the reports, everything on Veripic that can be viewable by defense is there. Of course, because of the nature of the charge, there are some things we can't put up there. I'd be happy, if defense does want to come in. We have a room set up to where they can view those images to kind of check that box if need be.
okay. All right. So has an offer been tendered?
There has not. We've talked a little bit about framework, and that's something I'm going to go ahead and start. I'll
All right,
get an approved
please
offer.
whisper. Yes.
Yes, I'll get an approved offer and convey that to defense.
All right. So when will you anticipate having an approved offer?
I know my chief is busy today, but probably my hope is by the end of the week, if not then early next week.
All right. And how old are you?
23.
Yeah, just to go back to discovery briefly, there is a video that has to do with the SSM search that I know the state has it. I think they suggested it's been down, but again, neither one of us have looked at it yet. That's the biggest issue that we've been talking about from the beginning. Once we sort that out, then yes, we can talk about this.
All right. So when is that going to be sorted out? When will he have that to view?
I'm in trial again, so not today, soon.
All right. So where are you in trial? Okay.
Yeah.
So what are you going to be asking for a motion to suppress or what?
At this point, that's premature, Judge. Apparently there's a consent for question is the matter in which is signed, what is told, if it's on video, did they record it? I do have the actual document, the state has provided that to me. So it's not overly complicated. I think it's a matter of looking at the video.
All right, Norma, set this for a plea deadline date and potentially a motion to suppress the week of July 28th. July 28th?
28th. Okay.
All right, once you sign the reset form, you're excused. Thank you.
All right. Thank you, Your Honor.
Thank you. No, set it as a motion to suppress and a plea deadline date. Yes.
Right.
Yes. Oh, yeah. It's like
Who is here on Jorge Sandoval? All right, Mr. Sandoval.
Good to be at your court early, Judge.
Thank you. Good morning.
Morning.
Are you all ready to proceed on the motion to revoke?
Yes, ma'am.
All right, this is Criminal Trial Division. It's a motion to revoke.
Okay, Judge.
All right, the court is calling 2023 CR 11289, State versus Jorge Sandoval. Can I have parties announce?
Jason Garahan for the state, Your Honor.
Robert Robach for Animan. For Sandoval.
And are you Mr. Jorge Sandoval?
Yes, Judge.
Did you review the documents entitled Motion to Revoke Community Supervision and State's Motion to Supplement pending motion to revoke probation with your attorney? Did you understand it?
Yes, Judge.
Are you the same Jorge Sandoval who was placed on community supervision in 2023 CR 11289 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on January 30th, 2024 for a term of 5 years? Is that you?
Yes, Judge.
All right, state.
Yes, Your Honor. Violated condition number 1 on or about the 12th day of November 2024 in Medina County, Texas. The defendant Jorge Sandoval committed the offense of evading arrest or detention with a vehicle in violation of condition number 1.
How do you plead to that? True or not true?
True, Your Honor.
Your Honor, we'll waive the remaining violated conditions.
Any objections to the waiver?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 5 years in the prison?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor, and it is to revoke the individual offers probation and to reform the underlying sentence to 2 years in the Texas Department of Corrections.
All right, thank you. And are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, has he done anything on probation? Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Jorge Sandoval.
All right, have you done anything on probation?
I completed the Saturday, I completed the aftercare program. My UAs were clean. Reason I wasn't reporting because I was incarcerated for 6 months.
Mhm.
And I got extradited here for the MTR.
Well, I mean, that doesn't have anything to do with the evading arrest, detention in a vehicle. So at some point you were not incarcerated, you were evading the police in a vehicle. So other than going to SADF, which if the court ordered you in an inpatient treatment, you had no choice. So you're a captive audience at SADF. So other than SADF, did you do anything else?
Work.
Probation?
Judge, Mr. Sandoval completed the SADF inpatient treatment. However, the aftercare was, there was the violation of program. He did complete the intensive outpatient treatment. And out of the 100 hours of community service, he has a balance of 23 hours.
All right, so what was the issue with the aftercare with SADF?
I'll have to look in his file, or it's the just give me one minute.
What was the issue with your aftercare in SADF?
Actually, with the community service, I completed all of it.
No, I'm talking about SADF. You had to go in inpatient for drug treatment. Then they have an aftercare program. So my question is, with the aftercare program, why did you not successfully complete that?
Oh, I finished it.
No, the report from probation is there was an issue with aftercare.
because I got incarcerated and that's why I couldn't report no more.
Okay. And what were you incarcerated for?
For
This, the evading?
Yes, ma'am.
So you didn't successfully complete aftercare because you picked up new charges. Why are you picking up new charges? I don't understand.
Actually,
Mm-hmm.
Judge, he has been in for over 245 days.
no, it's 580 days.
Violation of the new event was why he was exited from that church.
All right. This is what the court is going to do.
Watch this carefully because the entire courtroom just shifted. Up to this point, it sounded like the defendant might catch a break. But the judge has clearly heard enough, and the next sentence is about to hit hard.
And it helped you maintain your sobriety. When you're released from prison, if for some reason you can't find a place to go that can help you maintain your sobriety, if you come back here, I'll pick up the phone, call somebody. You understand? To help you. Did you,
What do you mean, like a place for sobriety?
to help you maintain your sobriety? Because obviously you still have drug issues.
Well, I'm planning on leaving the state.
Oh, okay then. Well, somebody there will probably be able to help you. And I wish you the best whatever state you choose to live in.
Thank you, Your Honor.
All right. Did you review the documents entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right. You have a limited right to appeal. And that right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Do you understand?
Yes, Your Honor.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right. And I'll give you credit for any successful completion of inpatient treatment. All right. Is there anything else?
Nothing, Your Honor.
All right. And I don't think we're off the record. I don't believe any of the new number ones are here in Bexar County. Is that correct?
No, Your
They're
Honor.
all Medina.
They're all.
So you'll have to see about those cases if you have not taken care of them there.
Yes, Your Honor.
All right. Good luck to you. Okay.
Thank you.
You're welcome.
Thank you, Judge.
So,
Luis Candaria.
Who is here on Luis Gandaria?
Present, Your Honor. Ready on that matter?
All right. If you'll have your client come forward. Thank you for pronouncing that correctly, Laura.
You for saying my name. That's church. I think you're saying my name right.
I'm working on it.
Mhm.
All right. So you have a motion for a bond.
That's correct, Your Honor.
Has the bond been set or no?
He's currently remanded without bond. I did file just this morning a motion for PR bond because I did associate that with the newly indicted case.
Mhm.
And I did file this writ as a result of going over the 90 days
Mhm.
without indictment. We're currently at the 111th day.
Mhm.
And as per Odyssey court records, the matter was indicted yesterday.
Mhm.
And I know that as per 17.151, the initial burden is on the state to make a prima facie showing that the case was indicted within the 90 days, and I don't believe that has been done.
All right. Was the case indicted within the 90 days?
No.
All right. And so what are you requesting
We're
before we go on
requesting,
the record?
A PR bond, Your Honor. My client is indigent. He can't make really, any.
Okay, all right, so we'll go on the record. I'm just trying to figure out
Oh, yes.
what's happening. So you requested a PR bond. The state has already said they didn't indict within 90 days. All right, court is calling 2025 CR 00. Oh, before I go on the record, have you had a chance to review the state's file
Regarding the newly filed case,
regarding, is there another case other than the unauthorized use of vehicle?
felony, no, ma'am. He has a couple of misdemeanors.
All right, have you had a chance to confer with the state on this?
Not on this, Judge, because I did see some preliminary offense reports, but the matter just did get indicted yesterday.
What do you have in your file? Or you reviewed the state's file?
Well, the thing is, Judge, that I'm kind of pressed for time this morning. That's why I came here early to get this hearing before the court. And then I was going to request the PR bond also because I need time to review that discovery with my client, the videos, and all the reports. And since this matter just got indicted, that really triggered me to see about going upon my client's defense, knowing that the state was finally going to move on his case. So,
Right, and you have all of the videos, correct?
I have no idea.
it just says it just got indicted yesterday, Judge. I have not been able to look into that. My efforts have been focused on the writ.
All right, does anybody know what his criminal history is?
Locally, yes.
All right, let me see.
PG 1 to 4, for which he was sentenced. A felon possessed firearms, and seems as though it was dismissed. Give me a moment to check on that, Judge.
Okay.
That was dismissed.
All right, so what is his NC?
Authorized use of a motor vehicle for which he was sentenced.
Does he have any out-of-state history?
Don't know, Judge.
Can you run that to see if he has out-of-state history?
I cannot. I can ask our investigator to run it.
All right, if you have the investigator run that.
Never lived in the United States. No. Your Honor, would it suffice if my client under oath testified as to his potential out-of-state record? He's saying he never lived out of state, has no offenses anywhere out of state.
Okay, and I'm looking on my system too, but the system is running slow. All right, the court is calling 2025 CR 006612 State versus Luis Antonio Gandaria.
Yeah.
Sorry, Junior. Could I have parties announced?
Andrew Harris, Settlement for the state.
Rene Munoz on behalf of Mr. Gandaria.
And are you Mr. Gandaria?
Yes.
Right. Counsel, you've filed a motion for a bond, and off the record, both parties agreed that your client had not been indicted within the 90-day time period. So what are you asking for, counsel?
We're respectfully asking for a personal recognizance bond. My client has been in custody for the last 111 days, not able to make bond. He does not have any kind of resources in terms of having a job or employment to make bond, as well as friends and family are limited, that they will not be able to have him make a sufficiently bond if reduced. That's for the foregoing reasons why we're requesting a motion for personal recognizance bond due to and using the mechanism of the 17.15 writ that was shown to be in violation of in this instance.
All right. Do you want to call your client with regards to the amount of bond he's able to make?
Yes, Your Honor.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand, state your name for the record.
Luis Antonio Gandaria Jr.
All right. You're going to need to slow it down because the court reporter has to take everything down. And if you'll speak up so the court reporter can hear and so I can hear. All right. Defense, you may proceed.
Thank you, Your Honor. Mr. Gandaria, are you currently in custody at the Bexar County Jail?
Yes.
Okay. And how long have you been in custody there?
And I've been locked up since November 9th.
Okay. Then you got out and then you've been in custody since February, is that correct?
Yes.
Okay. At this time, are you currently employed?
No.
Do you currently have any amount of savings that would allow you to make a bond if the bond were set at a certain amount?
No.
Okay. Do you have any family or friends that would be able to assist you in making a bond that the court may set?
I don't have a dad. I only have a mom.
Okay, so you need to speak up. And I know you're speaking towards him, but
I only have a dad. I don't have a dad. I have a mom.
Okay.
And it's on mom.
Okay. And then your mom, is she employed?
Yes, but you want me to come?
Oh, she makes a little money to sustain herself and her
Yes.
household. Okay. Have you lived or resided anywhere outside the state of Texas?
No,
Okay. Do you have any criminal history outside of the state of Texas?
I do not.
Are you swearing that under oath today for the court?
Swear I know it. Oh, I don't have any warrants or been out of Texas.
If you are able to make bond, would you attend all court sessions as required?
I will.
Would you follow conditions of bond if the court were to set them?
I will.
If the court required you to check in with the pretrial officer, would you check in with that office as required?
I will.
Those for the questions, Judge.
all right, any questions?
A few. I want to make sure that I understand this correctly, Mr. Gandaria. You were originally arrested on September 27th, 2024, correct?
Yes,
And you were released pending that court appearance?
yes,
And subsequent to that, you were arrested and charged with the offenses of evading arrest and the instant offense unauthorized use of a vehicle, correct?
yes,
So you are still pending trial for the September 27th, 2024 offense, is that correct?
yes.
Thank you.
Just a couple follow-ups, Judge. Regarding those offenses that the prosecutor listed, have you been found guilty beyond a reasonable doubt as to any of those offenses?
No.
Okay. No further questions, Judge.
All right. I do have some questions of him, but I have some procedural questions. So with regards to the cases, the evading arrest, detention, and the burglary of the vehicle, were those cases alleged to have been committed before or after this case?
The burglary of the vehicle, as far as I'm aware, occurred prior to the instant offense. The evading arrest arises out of the same criminal episode.
All
As
right.
far as I can determine.
All right, so then my next procedural question, with regards to the burglary of the vehicle. I'm assuming he had that case pending, then he bonded out. And then that's when he's alleged to have committed unauthorized use of a vehicle and evading arrest, detention.
Yes, Your Honor. We're understanding the timeline.
All right. Now I have a question for you.
Yes.
Have you ever had any type of mental health diagnosis or been on any type of medication for mental health issues?
When I was younger, I was bipolar, so bipolar.
All right. Everyone, we're on the record. Then my other question for you is, have you ever had any type of drug use in the past?
Like growing up, yeah.
All right. And what would that be?
We,
Anything other than weed?
I mean,
Everyone, we're on the record. Please stop talking to the right of me because I'm trying to concentrate on what they're saying. Yes. So other than the weed,
I messed around with meth, but not so much
how long has that been?
in years.
Years? How many years?
5.
All right. Any other questions?
Not from the state.
All right. So defense, I know that you're requesting a PR bond state.
17.151 speaks of at least one of two alternatives: release on a personal bond or by reducing the amount of bail required. So it seems to me that considering Mr. Gandaria's recent criminal history, release on a personal bond does not seem wise. His current bond is set at $5,000. Considering the relative paucity of information provided by the defendant, for instance, that he has not actually brought in any other witnesses to testify to their financial circumstances to substantiate his lack of ability to make bond, the state recommends a reduction to $2,500.
Your Honor, in response to that, 17.151 does not state that a PR bond is triggered or a reduction is triggered because of, with respect to criminal history, severity of offense. The bottom line boils down issue is the state did not move on this in a timely fashion. And this has caused myself as defense counsel to now just at the 110th day have access to these things, which slows down the court, slows down the judicial process. Relative to this, the violation of 17.15 has been shown. Thus, it's triggered for the court, obviously, to determine if the PR bond is whether to be granted or not. And my client testified, I believe honestly, that he can't make any kind of substantial sum to a bond. And because he's been in custody with 110 days and hasn't bonded out, also further represented by the Bexar County Public Defender's Office, has been shown to be indigent. That's why he was appointed to the Bexar County's Public Defender's Office to begin with. That we're asking for a PR bond to be granted so he has the chance to prepare for his defense, not in custody. And it's not any fault of his. These are just allegations. Nothing has been proven beyond a reasonable doubt. And he's been waiting patiently for the opportunity to defend himself of this charge, which has just arose in terms of a formal indictment yesterday. So for those foregoing reasons, Judge, we're respectfully requesting a PR bond that will lead to the efficiency of this case being resolved and his constitutional rights being intact due to a lack of timeliness on the state to indict his case.
May I make one further remark, Your Honor?
Yes.
It seems to me that perhaps 17.151 is not applicable in this case to begin with, because Section 2 of that article provides that the provisions of this article do not apply to a defendant who is, subsection 2, being detained pending trial with another accusation against the defendant as to which the applicable period has not yet elapsed. And that seems to be the case in cause number 2025 CC 002343, for which the defendant was taken into custody, as far as I can tell, on February 12th of 2025, and information was timely filed, and he is pending trial on that accusation.
All right. And that's why I was asking the parties the legal process as far as the time. All right. This is what the court is going to do. The court is going to grant the PR bond. I'm going to set your bond at $5,000, grant a PR bond. I'll ask that the fees be waived. There's to be no driving. There's to be regular UAs, a referral to Center for Healthcare Services just based upon what he said about his previous mental health. Any other conditions state you will request?
Partial GPS tracking, Judge.
We'd oppose that, Your Honor. If he's going to be going to regularly UAs and referral for CHCS appointments, we would request as limited movement to curtail him trying to get himself into services and treatments. He has this case as well as the misdemeanor cases. He would still need to make a bond on or have a judge rule on that. And he's already agreed to make all appointments as required and show up to court and kind of do some kind of deference in terms of him showing up to court or not. And if he doesn't show up, then we weren't obviously there. He's not, with the understanding that he's not going to be let out because his case has already been indicted. But since just the indictment just happened yesterday, we're requesting that he be allowed leave to attend some of these appointments to get to the root cause of what may be causing him to enter the criminal justice system.
All right. And the court will note for the record that the court does not, and I've done the research, the court does not see any violent history in his past that would warrant GPS. But I do know that there is an issue with him driving vehicles that do not belong to him. And I'm basing that upon the indictment where you've been previously convicted of unauthorized use of a vehicle. So the court's conditions will stand. Ms. Ferguson, on this case, I need a 30-day reset. And that is going to be received all discovery. Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Probation, this is an application. Ms. Hayes, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge, waiving count one, proceeding on count two.
No objection.
Did you review the admonishments with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
In count two, you're charged with the offense of possession of a controlled substance, penalty group 1, 1 grams to 4 grams as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
She has to sign. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Hayes, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 2. They're asking that your punishment be assessed at a $2,000 fine. They're recommending deferred adjudication, and they're asking for restitution to SAPD for drug testing. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations? Then to the offense in count 2, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Should be contained in Exhibit 1 and attachments, Judge.
No objection, Your Honor.
State, you may be excused.
Thank you.
Did you review the document entitled waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, and laboratory reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
The court follows recommendation.
All right. Do you have any children?
Yes, ma'am.
What are their ages?
16 and 11.
Who do they live with?
Me.
Are you employed?
Yes, ma'am.
What do you do?
Right now I'm doing Lyft, but I used to work for CPS.
I'm sorry, what?
CPS.
What is
Energy.
CPS? Oh, CPS Energy. If you're drug tested today, what are the results going to be?
Clean.
All right, when's the last time you used?
About 5 years ago.
I'm sorry, what?
5 years ago.
All right, this case is not from 5 years ago.
Your Honor, that it was not for her consumption regarding the drug.
All right, so I don't even understand. Is Child Protective Services involved?
No, Your Honor.
I don't understand why not. So I have concerns, and these are my concerns. She has a 16-year-old and 11-year-old living with her. And according to what I'm reading in the police report, she was dealing and the car is smelling of marijuana, and then the car has license plates that don't belong to the vehicle. It comes back as a different vehicle. Then she has this person who's with her. Who is that?
My husband.
All right, then, so you have her husband who's involved in all of this, and they have a 16-year-old and an 11-year-old at their home. That's an issue.
I understand, Judge. As you can see, this is a little older case. This isn't just from a month ago or a couple months ago. I do not believe she has any priors. I believe there was a prior charge, but it was dismissed. This was a one-time thing, Judge, and she has been on the straight and narrow since then, and even prior to that, Your Honor, she has.
All right, so let me just tell you what's going to happen. I'm going to follow your agreement, but I'm going to have you drug tested today. If that drug test comes back as positive, then she's going into the Bexar County Jail to be transferred for inpatient treatment.
Okay.
All right. Probation. On this case, this is what the court is going to do. The court is going to sentence you to 6 years deferred adjudication. I'm going to want field visits 1 time per month until further notice. Please tell probation to check on the children. There's to be regular reporting by Zoom or in person, regular random UAs. Do you have your driver's license or identification with you?
Yes.
Okay. There's going to be a $2,000 fine. That will be probated.
Thank you, Judge.
Restitution to SAPD for drug testing. There's going to be 200 hours of community service restitution. I'm going to require that she completes parenting classes. Once that's completed, the community service hours will be deemed satisfied. There's to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. And with regards to the no employment with minors, that includes if somebody wants her to babysit, you're not allowed to babysit. There's to be a TAP evaluation out of custody, follow recommendations. And I'm going to ask for a UA today. So once probation goes over your conditions, you're going to leave directly from here and go and obtain your UA.
Okay.
Probation, is there anything else? Yes. All right, is there anything else you need from the court in order to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And I just have a question for myself. We can go off the record. So where were your children during this entire, at home alone?
No, with my parents. My parents live with me.
All right, so now I know who's raising the children.
Oh, no.
Okay. Well, I mean, you were not doing it that night.
It was one night.
But you, according to the police report, you all were smoking marijuana in the vehicle
I'm allergic
because the
to
car smelled like, oh, you're allergic to marijuana, but y'all driving around with marijuana in the vehicle and the smell of marijuana. I find that very odd. I have some more luggage to unpack with her, but before I unpack that luggage, I want you to speak with probation, and then you're immediately going over to felony drug court.
Okay.
And probation, put her on the UA hotline.
Yes, ma'am.
All right, you entered a plea on April 21st of no contest. According to the plea bargain agreement, the state is recommending deferred adjudication. A PSI was ordered. Have both parties had a chance to review the PSI and TAP evaluation?
Yes, Judge.
We have, Your Honor.
Any objections to the PSI or TAP evaluation, state?
No.
Defense, any objections?
None.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor. We've reviewed the PSI, and I know that they marked that the defendant has minimized guilt. Mr. Villa, in his statement, I don't think he's minimized guilt. He did accept responsibility. He realizes that The actions he took, including leaving his property, kind of removed any self-defense he could have alleged, and that's why he accepted responsibility for this. He is expecting his first child. His girlfriend is scheduled to be induced this evening at 7 p.m. So this is 7 p.m. That'll be his first child. They're expecting a little girl. He does have gainful employment. His employer does do random UAs, not to suggest that the court doesn't need to do their own safeguards, but that is also one of the reasons why he has not used any marijuana or THC in the past year. This offense occurred when he was just over 18. We believe this is going to be an excellent opportunity for him to take something from this, learn something going forward, and we think he'll be a good candidate for deferral.
Okay. Anything you wish to say?
No,
Are you employed?
yes, ma'am.
What do you do?
I work at the kitchen in the Windland Foods. I'm the mix prep. I mix vegetables for the mix sauces.
Oh, okay.
Yes, ma'am.
What type of vegetables? I'm
Oh,
always interested.
jalapenos, onions, and all that. Just mainly that fresh vegetables, like tomatoes and all that from someone else.
Right.
And spice kits, all the spice.
I always have an intention to do that myself instead of buying it. It never works out. So what are your plans to do for the rest of your life? I see that you completed high school. So what is your dream job? What do you want to do?
Oh, I would like to stay here and become bigger there, supervisor and all that stuff. I want to have my family, my beautiful family, and support them and be a good man for my family.
All right. And these people that you were having issues with, are you still living in the same place?
Oh,
Are you moved?
yeah, I know. I moved away, but I mean, they still live there. But just to know that we passed like nothing.
All right. And so do you have any occasion to go over there? There's no reason to be over there?
Yeah, just to go wash clothes at my mom's house and stuff. I mean, nothing happens. We just
They live
Um,
about 3 houses away, his mother and the complaining witness,
All right.
and his grandparents.
yes, ma'am. My grandparents
Okay.
next to me.
All right. So they say that you're just a child and they just want you to apologize to their mom. That's all they want.
Yes.
And they said that's all they wanted from the beginning. They don't want you to go to jail. They want you to have probation. So this is what the court is going to do. And state you may be excused.
Thank you, Judge.
The court is going to sentence you to 3 years deferred adjudication, 100 hours of community service restitution. I'm going to order parenting classes. They're always great when you're expecting.
Thank you.
So I'm going to deduct 50 hours once he completes the parenting classes. The other 50 hours, there's going to be a letter of apology that you need to write to their mom.
Okay.
And once you've done that letter, then your community service hours will, another 50 hours will be deducted from your community service hours. Because sometimes with letters of apology and apologizing to people, sometimes you're not in the wrong, right? But then just apologizing cools down temperatures and then everybody's fine.
Okay. Sounds good.
So I'm going to order that
Yes.
because that's what they say that they want.
And Your Honor, that's to be turned into probation?
Yes.
To the family directly?
Yes.
Thank you.
There is to be no contact with Nicholas Rodriguez or Romero Rodriguez. There's going to be proof of employment within 30 days, no employment as a home healthcare provider or with minors, regular reporting by Zoom or in person, regular UAs, probation. Is there anything else you would recommend? Thank you. Let's do field visits 1 time per month for 3 months. All right, is there anything else you need from the court to help you?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. In this court, to be successful in probation, communication is key. If there is an issue, let your probation officer know. If you feel they're not addressing it, you can always come back to court and address it with me. What I can tell you is when you have children on the horizon, first off, the grandparents are going to be very excited. They may want to be overly involved, but let them be, because you'll need some help. And sometimes it can get stressful. And because you are doing probation, and it seems like it's a lot, if it gets too overwhelming, just let your probation officer know. You understand?
Yes, ma'am.
All right. Thank you for dressing appropriately for court. Just remain in the courtroom and probation will go over conditions with you.
Thank you.
All right, good
Well, I
luck.
don't know if it's important for the court's file, but he does work nights at this job that he works, so.
Okay.
Reporting in the morning for.
All right, the court is calling 2025 CR 002023, State versus Gregory Gonzalez Pruneda. And probation, this is sentencing, and it appears to be an application. All right, could I have parties announce? Counsel, you on this side.
Oh,
Yeah. No problem. All right, this fee bargain page is, let's go off the record. All right, so there's an issue with the plea bargain. The plea bargain says punishments be assessed at 2 years. It doesn't say whether or not the state is opposed to the application or recommending probation.
On the bottom, below the line.
No. They say, but they're still supposed to say, are you all silent?
State recommends.
All right.
We discussed that a few minutes ago.
All right.
Below the line. No, my initials on too, Judge.
Yes, please. All right, we're back on the record. So you're here for sentencing. According to the plea bargain agreement, the state is recommending community supervision. They're asking that your punishment be assessed at 2 years in the prison. And they're requesting that your community supervision also be for a length of 2 years. Have both parties had a chance to review the top evaluation and PSI report, state?
Yes, Judge.
Defense?
Yes, Your Honor.
Any objection, state?
No, Judge.
Defense?
No, Your Honor.
All right. So according to the TAP evaluation, they're recommending inpatient treatment. It appears that you do need inpatient treatment. Do you agree with that?
Sure.
Right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Gregory Gonzalez Pruneda.
All right, so they're asking for inpatient treatment, and state you may be excused.
Thank you, Judge.
It appears that you do need treatment. And the reason why I say that is you have previous history where you didn't do well on probation. Your probation was revoked. You were sentenced. And a lot of your cases, they're all drug cases, except for a couple. And in one case, I think this is wrong. They said you were sentenced to 1 year in prison, but I believe that's supposed to be 1 year state jail facility. And then there's another one where you're sentenced to 3 years in prison, and all of this is from drug use. So it appears to the court that you do need inpatient treatment. So here's the thing. I can follow your agreement. You're going into inpatient treatment. You're going to remain in custody, going to transfer you to inpatient treatment. I can ask that he also be referred to felony drug court. Felony drug court, of course, is at capacity. They may have room for him. They may not. They may put him on a waiting list. But I think he needs inpatient treatment. So I can do that. Or if you say, you know what, I don't want to do this at all. They've already agreed, according to your plea bargain agreement, that your minimum, the maximum amount of sentence I can give you is 2 years. So you're going into somebody's inpatient treatment program. So if you don't want to do that, tell me now, and I'll just send you to prison for the 2 years. All right, off the record for a moment. Bashan, I'm going to send you an email. It's unrelated to this case. I think that person is trying to go to RMS for testing. Oh, she's still here. Hi. No, she's not. My glasses are off. Oh, that is not you. Okay. All right. So I'm going to send it to you because I think she went somewhere else. So I sent you the email. All right. We're back on the record.
Since, I've been here since December 30th.
So you have a choice. If you want to go to prison, I can send you to prison for 2 years. Otherwise, I'm following this recommendation for inpatient treatment. I'll do, like I say, I'll do a referral to felony drug court. If felony drug court is at capacity or they don't accept you, you'll be going to inpatient treatment because that's what they're recommending.
The judge, there was another, while you were doing that other matter, he was asking about his good time. I can't promise him a good time other than the time he's been, his back time, he's been in jail since December 3rd.
I mean, the only thing I can give you credit for is time that you were in custody. Whether they're giving you 2 for 1 or whatever they're doing at the jail, that's completely up to the jail. If I sentence you to 2 years in prison, that's saying at most you're going to get 2 years in prison. So no one can give you more than the 2 years that I was sentenced you to. Now, whether someone is giving you good time credit or giving you counted it as less, technically as less than the 2 years, that's up to the institution. I have no control over that.
That's what I was talking about.
Yeah.
First on the south side, I'll get it to one. But DDC, they make difference to you. She's trying to do it. She can't do it. All she can do is give you the background to do something. It could be 6 months now.
So, for example, if you have been at the Bexar County Jail for 6 months, and I say you get credit for any time that you've been in custody, at least you're getting 6 months. Now, if the jail is doing 2 for 1, 3 for 1, or whatever they're doing, that's completely up to the jail. So there's no good for you to write me a letter and say, hey, I was supposed to get, 8 months credit because I was supposed to be getting 2 for 1 or 3 for 1 at the jail. That's the jail's calculation. The only thing that I can say is this is what you're getting credit for.
In this case, would be back to December 3rd. Okay. And then felony drug court will be a conditional. You said that you would recommend felony drug court?
Yeah, but felony drug court may not be able to accept you because they may be at capacity. And if they're at capacity, you'll be placed on a waiting list and they'll probably send you to inpatient treatment until they have a space for you. And that's a 2-year program. So I will place you on probation for at least 3 years because that program is 2 years. And if you successfully complete that program, sometimes they'll recommend that your probation be terminated early because you successfully completed their program. But their program is a minimum of 2 years.
Judge, he would like to apply for drug court.
All right, but here's the thing. I want you to hear me and internalize what I'm saying because it sounds like you really want to do drug court. I can't force drug court to accept you. If they're at capacity, then they're at capacity. But when drug court interviews you, you need to be 100% honest with them. You understand?
Yes.
All right. So this is what the court will do. The court will sentence you. I'm sorry, because another judge took this plea. Did he enter a plea of no contest or guilty?
Guilty.
I'm sorry?
Guilty.
All right. And for the record, the court did read the stipulations and the court is finding that there's sufficient evidence to find you guilty and the court will find you guilty. The court will sentence you to 2 years in prison, suspended and probated for 3 years. With regards to the drug testing, they're saying that, I think I've read it somewhere. they're saying that it's $220 for drug testing. Are you in agreement with that amount? That seems very high.
Well, I was gonna ask that it's normally 65 in that neighborhood. Maybe we got a new lab that charges the county a little more. Gregory says he'll abide by that price.
Okay.
That's a little, it's a little. Yeah, it's a little steep thing.
Yeah.
65. I saw 220 and I was thinking maybe it ran 3 tests. I don't know.
All right, so we'll do 200, but I'm not giving you a fine, so $220 for drug testing. And that's to be given to SAPD. In custody, the following. There's a referral to felony drug court. If not accepted in felony drug court, then SATA, proof of employment within 45 days of release, no employment as a home health care provider or with minors, regular reporting by Zoom or in person, regular random UAs, field visits 1 time per month for 6 months, 60 sober meetings in 60 days. Do you have any children?
Yes, ma'am.
What are their ages?
12. She just turned 12 this month, or last month.
All right, there's going to be 100 hours of community service restitution. Once he completes parenting classes, the community service hours will be deemed satisfied. All right, probation, is there anything else? Is there anything else you need from the court in order to be successful?
No.
Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing, in this court, to be successful on probation, communication is key. If you have an issue, let your probation officer know about it. If you feel that you're going to use or that you are maybe backsliding, heading into relapse, pick up the phone, call your probation officer. Your attorney will tell you that once you're placed on probation in this court, I'm hoping that you're going to be successful. Everybody wants you to be successful. You understand?
Yes, ma'am.
I take no pleasure in sending people to prison, but he will tell you I will send people to prison, but I take no joy in doing that. So you need to be clean and sober for your 12-year-old. If you're not going to do it for yourself, do it for your 12-year-old. You should be doing it for yourself, but if not, do it for your 12-year-old. And if you don't get your life together and be clean and sober, somebody else is going to raise your child. She's going to be calling somebody else dad, not you. And then the last thing you want is for somebody to have to identify your body because you've overdosed or somebody is visiting you at the jail. I don't think you want your daughter to have to come visit you at the jail, right? So where you are now in your life, hopefully it's not where you're going to end up. We're all on this journey of self-improvement. So this is a chance for you to improve yourself. I know you've been unsuccessful on probation before, gone to prison before, but this is another chance, an opportunity for you to do better. Okay. All right. Good luck to you. Thank you. Okay. And you know what? And he's clean.
Yeah, he should be. I was going to ask you on the thing. I don't know. I had one client that asked about, you asked him, have you used?
Mhm.
Well, not since I got out of jail. Sure, the police once were.
Yeah.
But I heard you on a quote. Tell the truth, damn it.
2-4 State versus Jason Moore. Could I have parties announce?
Zach Dunn for the state.
Mario Del Prado comes from Moore.
Are you Mr. Moore?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
I think at this point, I think, Your Honor, that we're going to withdraw that. He's been accepted in the Veterans Treatment Court, so we asked the court to
So, Your Honor, just for candor and clarity, of course, there's only one violation with respect to the MTR, one that the state believes they would be unable to prove. And we had let defense counsel know that this morning. And the defense, of course, let us know about the recent Veterans Treatment Court acceptance.
All right, so then here's my, yes, probation.
So Judge, he was accepted into in the Veterans Treatment Court program. However, their orientation for him will not be done until the end of the month. They do not have a set date yet on when he'll be scheduled.
All right, and then, so is he gonna remain in custody until he's transferred to BTC or?
Well, Your Honor, I would think that if there is no MTR pending and there's
Well, I haven't signed a motion to withdraw because I haven't received a motion to withdraw. This is what my concern is. My concern is, state, you're saying that you don't think you'll be able to prove up the number one.
I think we're in a difficult position, Your Honor, yes.
So my concern is that the number one hasn't been dismissed. And if he's released from custody, have that out there. And I don't want any issues to occur that he's released, because then we're going to be back here with another motion to revoke.
Yes, Your Honor. Is it potentially, or is it possible, if you will, that I could take care of some things at the misdemeanor level to kind of just make things?
And that's what made this courtroom session so powerful. Some defendants lost their freedom. Others were given one final opportunity to turn their lives around. But every single person who stood before this judge heard the same message. Excuses stop working eventually, and choices always catch up with you.